So today we're talking about the discovery phase of a lawsuit. This is a critically important stage of your case because it's essentially where you have to prove your case. And if you don't, it could be thrown out. On the flip side, usually when discovery is over, that's when your case will settle, either through direct negotiation or a process called mediation. So it's very important that the discovery phase goes smoothly and that you get the most that you can out of that process. So what is discovery? Well, simply put, it is the exchange of information between the parties. And it starts with a simple process called interrogatories, which is a fancy word for written questions. Basically, the other side will send you questions and ask you a bunch of information. Now, one of the big things to know about this is that they can go really broad in these questions. And they can go ask about things that you'll think, why does this have anything to do with my lawsuit? So to understand that, let's talk about what the standard is for discovery. So most states use the old federal standard, which said discovery has to be reasonably calculated to lead to the discovery of admissible evidence. The new federal standard is that discovery has to be proportional to the needs of the case, which is not really all that different in practice, but can be in more complex situations. The thing to know about this is discovery does not have to be admissible. You can ask the other side and they can ask you about things that will never come into evidence. For example, where have you worked for the past 10 places, and who are your, give me the name of every supervisor you had at every job you had for the last 5 years. What does this have to do with anything, right? They can ask it because they might have some, they might want to follow up with that person and say, tell me about, so the plaintiff, tell me about so-and-so and how they were as an employee. They might want to know who your roommates are or were in the past, just to kind of get a full picture of you and do some investigation. And none of that is going to come into the trial under the rules of evidence, where much stricter rules apply to exclude extraneous stuff. But during discovery, it's much broader. So one of the first things to know about these interrogatories, written questions you're going to get, is that they're going to probably confuse you in terms of, why are you asking me this? This is so broad. Who cares about this information? This has nothing to do with my car accident or whatever the case is. But that's why they do it. They're trying to get a broad picture of who you are, of your past, of any pre-existing injuries you might have, or pre-existing work problems you had, if you were fired for stealing from your last job, for example. That might be relevant information for them to use or possibly use as impeachment or something like that. So they can dig in at discovery in a way that they won't be able to just put this stuff on as proof at trial. But discovery is much broader than admissibility at trial. That's the big thing to know about interrogatories and the written questions. The next phase of discovery after written questions is depositions. Essentially, depositions are the other side's opportunity to put you under oath and ask you questions about, again, the same broad standard, things that might lead to admissible evidence, things that aren't necessarily strictly relevant, but could lead to the discovery of relevant admissible evidence. At the conclusion of discovery, one of two things happens. I'm oversimplifying, but generally. Either your case settles, they agree that you put enough meat on the bones of your case, you proved it, you've established all the necessary elements, and they talk settlement, whether directly or through a process called mediation. Or they say, no, we're going to file a motion for summary judgment to try to get your case thrown out. And I have a video on that too, but that's essentially, they can try to say, as a matter of law, the court should dismiss your case because the proof in the record, based on what was established during discovery, does not hit a key element. You failed to prove some key piece of your case. And they'll try to get the case thrown out. I have seen it where cases will settle while those motions are pending. And I've seen it where, obviously cases get thrown out, or I've seen it where the summary judgment motion is denied and then they settle the case. In a very rare case, The case doesn't settle, it proceeds to trial. But most cases, if they've been filed, will resolve one way or another during discovery. And the key takeaway for you as someone watching this video is simply that don't be shocked that discovery is kind of a burdensome process and the questioning is way beyond what you think is the relevant scope of what we should be talking about in your case. It is broad by design to allow the parties to figure out the whole possible universe of relevant information. How long does discovery take? It can take a long time. I mean, I don't have a better answer than that. Months, sometimes years, depending on the number of experts, number of witnesses. If you're litigating a case, you can have a lot of depositions. It can add a lot of cost to your case, which is, something we often talk about when we think about moving forward with the case, or should you take the best pre-suit settlement offer given what it's, time and expense of discovery. It can be a very burdensome part of the case, expensive part of the case, depending on what kind of matter you've got, especially medical malpractice cases, very expensive to litigate with all the experts involved. So, but I would say brace for at least 6 months, probably a year in terms of discovery. And that's, if you get into discovery related motions, which we haven't talked about, but you can have disputes in discovery about, well, I'm not producing this information, or I don't think that witness is relevant, or, this should be subject to a protective order, and I want to depose your treating doctors without you there. And there's a lot of issues that come up in discovery that are maybe more appropriately the subject of another video rather than just this video about a broad overview of what discovery is. But point being, there are all sorts of disputes that can arise that can slow the process down even more. So I would say on the short end, you might get lucky, it's smooth, it's just interrogatories, depositions. That could take about 6 months. If it's more complex, more witnesses, more medical experts, that could take a year or more. So I've mentioned the deposition repeatedly in this video. It is probably the most important day for you in your personal injury case if you're a plaintiff. So be sure you get that day right. So for some tips on how to do that, watch this next video on how to prepare for your deposition.